Very good evening, everyone. We're glad to welcome you tonight to our Legal English webinar series 2024. And we continue the series with our wonderful virtual English language specialist, Daniel Capretti. And today the topic of our webinar is Property Law 1, a rental agreement. And we're very glad that you are here. We would like to remind you that you are welcome to ask and answer questions in comments on YouTube or in our Telegram channel. And also those of you who are participants and who got registered for our webinars, you have been sent a link to the presentation and you can give your answers directly to the questions that Daniel asks. So our webinar will last for approximately up to 80-90 minutes, and I'm giving the floor to Daniel tonight. Very good evening, Daniel.
Hello, good evening, and good evening to all you wonderful people who have tuned in to hear about property law, which is probably my favorite branch of law to discuss. I worked in property law, so I had a lot of real life exciting experiences in dealing with the wonderful and sometimes very difficult world of property. And I would say that today property is especially relevant because the person on the other side of me is renovating their apartment or flat, as we'd call it in the UK. And there's been drilling and lots of drilling. Now, according to the regulations of our building, they should be finished by now. So I am hoping that they comply with these regulations and that we have a peaceful and quiet seminar. So today we're starting off with a rental agreement. And the one thing I want to say about property is, first off, well, two things actually. First off, property is full of contracts. So, you have to have some sort of agreement when someone moves into your house or sells the property. You can't get away from the contract in property. And secondly, property law in common law is very localized because there are different traditions. For example, in the US, there's a stronger tradition of home ownership. So the law is focused on more sales of property. Whereas in the UK, especially more recently, people don't have the money to buy a house. So there's a lot more about renting, that a lot more law being made in the area of renting. And remember, the American housing stock is much younger than the British housing stock. And having a very old housing stock in the UK, it creates all sorts of problems that you do not have in America. For example, here you have a listed building, and if your building is listed as historical and you want to change or renovate it, there's only certain things that you can do. So I find this an endlessly fascinating area of law, and I hope that you will too.
And I would like just to jump in and remind everyone that Daniel is a lawyer who got education in the United States, worked in the United States, but now she is, if I can share it, in London. So that's why she can really compare all of these, and it's very interesting. And can I ask you a question? So have you worked in property law in UK or in US or both, or maybe some other countries?
Yeah, in the UK. But remember, a lot of the founding documents of property, because there was a base, because it's common law based, were all important cases in the UK in the 1800s and early 1900s. So a lot of the founding principles, when we studied property at law school, we were looking at cases that were 100 and 150 years old. And that doesn't change because these cases in the UK created our ideas in common law about property. Today, we'll concentrate, though, on the American system because they're so different. I had to choose one. So today, we're looking at some principles that are specific to America, but I will tell you where there's a little bit of a difference with the UK.
Mm-hmm.
So before I start, a massive thank you to Sophia and our reload Jennifer for organizing these webinars. We could not do these webinars without you both and your wonderful commitment and support. Okay, so over to you. What words are related to renting property? So I'm interested to know what vocabulary you tuning in tonight already have in your property arsenal. So you can write them in on YouTube, Telegram. If you are using the presentation, you write the answer and then you press send, and that will come directly to me. That will come directly to me, and I can see exactly what you've written here. So property words. There are a lot many, but specifically try to focus on renting property.
Yes, because we would like to remind you that today we're going to speak about, so in general, our series, the one that we're having now while we're waiting for the answers from our audience, and we're focusing in generally mostly on contracts. So, and today we speak about rental agreement. Next time we'll speak about a sales agreement, as I understand, sales contract. Well, actually, Daniel, I have so many answers on YouTube.
I have answers here too. So a very engaged audience today. So why don't you go first with your YouTube answers?
Yes. So Marusia says landlord, tenant, deposit, Nikita, leasehold, quiet enjoyment. Super. So Nikita says freehold, eviction, Ivan, landlord, municipals, also tenancy and subletting.
Okay. And I have rent arrears. I really love that from Raisa. Thank you. Deposit, yes, very, very important. What else do I have here? A regulated tenancy. Wow, really some really nice vocabulary here. And while we're dealing with this, in Russia, do most people rent or do they buy their homes?
A lot of people rent, and a lot of people would like to buy. So, but and of course, it is a dream of many people to buy. And we had before, during the Soviet times, people usually could not buy. They could only exchange stuff because we sort of had, well, not such a concept of private property as existed in the Western world. Now, then there were some changes, and after the breakdown of the Soviet Union, the situation has changed. Now we have mortgages, and mortgage system, which and it fluctuates. So sometimes the interest rate is high, sometimes it is extremely high, depending on the situation.
I see. I think that's sort of everywhere. The dream is to buy, but increasingly, especially in the UK, young people don't have the money to buy. So a lot of older people, and I'm an older person now, my generation above will own their property. And then a lot of younger people are either living with their parents or they're renting in what we would say a flat share or an apartment share. And there's, a bunch of young people who live together. And I think that's sort of the wave of the future. Okay, I'm just checking to see, do we have anything more? I think I have exhausted all of my vocabulary here. Do we have anything more coming in on YouTube or Telegram?
A little bit, just rent control. And we do have some comments from the audience saying that, of course, people would like to buy more than to rent. And you're speaking about the words roommates and flatmates, I think.
Okay, roommates and flatmates. Yes. And I think it's interesting, this idea of buying, having a piece of property, because I think that's one idea that unites many people of the world, because I think in many cultures, the dream is to have your own place.
Yeah.
But renting is the reality, and especially if you're living in a place for a short period of time. Okay, very interesting. So let's get on to renting in Russia. So again, it's your opportunity to teach me, and this is my favorite part of the webinar always, because I get to learn something. And first off, let's discuss the difference between a landlord and a lessor, and a tenant and a lessee. Now, I've put a slash between them. They're synonyms. Can any of my legal eagles on YouTube tell me the difference, if there is any, between a landlord and a lessor?
Okay, we'll wait for the answers.
Yeah, that's a
I will also check Telegram channel. Maybe there's someone also giving the answers over there. So let me just see something. So, and we would like to say that we are very, very happy that we have such an engaged audience writing to us.
yes.
Actually, there is an answer, not there is an answer on YouTube. So, and there are very different answers. And I have received an answer on Telegram. So, Farah says that lessor has just right of renting. Landlords is owner. And on Telegram channel, we have another answer that lessor lessee is related to commercial property, and landlord and tenant are related to residential property. So, and also Natalia says that I think that lessee paid money he or she buy it too. So maybe it's related to like leasing, you know, when you are sort of renting over some period of time, and then you can have the right to at the end to buy it, something like this. So there are different answers. And there's also Ivan. Just a second, sorry. Yes, a landlord is a type of lessor, but is generally associated with renting out real property like residential or commercial spaces. A lessor can be any entity that leases out any kind of asset. And Marusia says that lessor is not just for real estate. So a lot of answers.
Okay, and there are many, many good elements of all of these answers, and I appreciate everyone's brain work here. So, at its most basic, a lessor can rent out any sort of property. I can lease my notebook to you. I can lease a chair to you. Any piece of personal or real property. Landlord is specific real property. So a flat, a house, a bungalow. Now, I would agree that generally landlord is used in a residential situation and lessor is used in a commercial situation, but they don't necessarily have to be. So you will hear, businesses talking about their landlord. Landlord is definitely the more common term, but think of landlord as a subset of lessor. So you can lease all types of property. Landlord is very specific real property, okay, which would mean a house or land. And the same thing with a tenant and a lessee. Okay, so a tenant is somebody who takes a piece of real property, a flat, an apartment, a house, and then the lessee I can lease my electronic device to someone. So tenant and landlord are a small subset of vocabulary specifically focusing on real property. And I think we had many kernels of those right answers in what everyone ventured to offer. So thank you very much. Okay, so we've clarified those terms. Let's look at first the landlord and the lessor in Russia. What are the rights of the, let's just really focus now on the rights. So landlords, what rights do they have in Russia? So I'd like to hear your comments on YouTube and Telegram. What are the rights generally? I'm assuming that these rights are in the civil code, Sophia. Would that be correct? The civil code would tell us?
Yeah. Yes.
Boy, these civil codes, they're great. They have the answer to everything.
And while we are waiting, yes, and Ivan says that it's stipulated in the civil code. This is a very standard answer. And while we are waiting for maybe more answers from the audience, more answers, as I do have a question on our Telegram channel. The question is that the person asks about the words hire and hirer and owner. As I understand, what they mean is that lessor lessee, in a lot of situations when, for example, you are hiring or renting equipment or some car, they will be called not lessor lessee, but hire and owner. Is it like standard, or a lessor lessee will be most often used?
Lessor lessee. Those terms are good, but they're more colloquial terms. So this would not be a term that you would use in law or a law court. But for example, if you were going to a boat, you wanted to take a boat out on the sea, and you went to the boat shop, you would probably say, "Can I hire a boat for the day?" So these words are very often used in common parlance, rather than being specific terms that we would be considered property law terms. So these, but they are very good to know.
Okay, thank you very much.
Good
so
question.
And speaking about the answer to your question, what are the rights of the landlord and lessor? So basically, this is the answer that we received, that it is all in the civil code. And also what is important to specify. So just to sum up the comments that we have, is that in Russia, if we speak about a landlord, usually we speak about condos. So every separate flat has its owner. So, and it's a separate landlord, you have the agreement. Basically, there is a sort of freedom and a little bit wild west. So if we speak about this one, so we usually have a situation when the whole building is rented, and there is a landlord that owns a building, usually in commercial real estate. We used to have these situations in St. Petersburg, at least where I'm based, is that the buildings where people were renting apartments used to belong to a certain person or a family or a home or some association. So, and you couldn't buy an apartment separately. You could buy only a building. That's why people were renting all their life usually, or they had a house. Nowadays, after the breakdown of the Soviet Union, people own their own apartments. So, and there are condos usually, if we speak about American sort of way. And so you sign contract directly with your landlord, and it's very personalized. So although, of course, it's fixed in the civil code, but it's not that regulated, I would say, as
very interesting.
Other countries.
Very interesting. Okay. Whereas, this is now almost contradictory, because a lot of property law regulates a rental contract. So, for example, in the US and in the individual states of the UK, states of the US, you will have regulations that say what must be in this contract. And we will discuss that when we get on to what is in a rental contract. So it's funny. It has a common law origin, property law, but in both the US and the UK, the legislatures have gotten involved in saying, you must have this, you must have this, you must have this to have a contract, because they see that it is important to regulate the relationship between the landlord and the tenant, so that the landlord does not have too much power.
Mm-hmm.
I mean, we'll see an example of that later.
And we have some also comments from our viewers. Natalia says that the right of the lessor is to receive the rent. And speaking about some other comments, we have very active Telegram channel, not channel, but some private emails that are being sent to us also on Telegram, is that in Russia, we need to understand that in Russia, a lot of people do not officially, as I understand, register, at least this is what I've been told, their rental agreement, the lessor, because sometimes they're trying to minimize their taxable base. Therefore, a lot of the rental contracts are falling out of the eyes of the law, sort of, understand. Yes, and that's why the lessor does have a lot of power here in this situation. And because people have no choice as to agree to sometimes some contracts, they have to be, they are sometimes helpless, if I may say so, in the eyes or in the hands of the lessor. But it depends. If you're a lucky one, everything is okay, then you're a lucky one. But it's, as I understand, it's more on a personal level sometimes.
Very interesting.
You need to keep it in mind, yes. So.
Very interesting. I will add too that in the UK, they have this wonderful system in terms of if I'm renting out to a tenant, the tenant will put the deposit, a vocabulary word that many of you mentioned, into a government managed scheme. So they put the deposit in this scheme and it earns interest. The landlord is not allowed to touch it until the end of the tenancy. And as far as I'm aware, I'm not sure of any state that has that. I definitely know they don't have it in Canada because I lived in Canada for a while. And this is a great, great thing because the tenant's money is protected, so the landlord just can't walk off with it. And if there's a problem, then the landlord can appeal to this corporation and said, look, here is the damage here. And the tenant will only get back the money minus the damage. And I had a situation like that once. And I was really happy that I could get
deduct some
money. Exactly. To get a deduction. So that's a really great system. So and very, very, very interesting. Very interesting. Thank you.
Very interesting. And we have a question from Marusia related exactly to this special government body. Who gets to keep the earned interest on this money that is being kept as a deposit? Because they're not just lying there like for nothing, or they are. So
the tenant.
The tenant.
The tenant.
That is so interesting.
Yeah. Yeah, because it's literally the tenant's money, and if they're a good tenant, they'll get it all back. But if they're not a good tenant, they're going to get it back minus. And I've never seen this in any other country. I think it is a really great system. I think every country should have that sort of system.
Yes.
Okay, let's move on. Thank you for the very detailed discussion here. It's really interesting. Let's move on to the duties of the landlord. So can the Telegram, YouTube, can you just write down what obligations does a landlord have? Maybe under the civil code, an ideal landlord, what would they be doing? Anything?
So that would be very interesting if we receive any answers, because there's such a variety. It so much depends on the landlord, from my experience of my friends, because if there are some, while we are waiting for the answers, so if there are some, I remember if you want, for example, as a tenant to do some changes to paint the walls, for example, it really depends on the personal relationship with the tenant. Sometimes they would say no. Sometimes they would say, yes, you could do whatever you want, but you cannot deduct it from the payment the rent you pay to me. Some would say, yes, you can deduct it from the rent you pay to me. So it's all very, very personalized, I would say. So
that's absolutely fascinating. It really is. It's so different.
But it's my experience. All of our participants can either add any comments, because we all have different experience, and I've seen so many different situations. So, and Farah says that lesser landlord's responsibility gets good quality assets, rent quality. Marusia says, I agree with Sophia. It's mostly decided by the tenant and the landlord individually. If you are lucky, if you get along. Natalia says, landlord, the real property must be clean from other right, duty to repair and fix. And Anastasia says, tenant is obliged to pay rent, to pay for any damage, to take good care of the property.
Okay, this is all now sounding to be in much more familiar territory. Take good care of the property. So let's move on because we've sort of dealt with tenant and lessee. Unless there are any other comments about
No,
this?
not
Okay,
yet.
so let's move on to what a typical rental agreement should have. Now, again, this will depend on where in the common law system you are making a rental agreement. In the States, property law is state law, okay? And sometimes it's local law because you have local housing codes. So these local provisions rather than federal provisions are going to say this is what makes a property contract. In the UK, there is specific legislation that will say these are the elements that any contract to be a reasonable contract that you can enforce in the courts has to have these provisions. And usually in the UK, they have standard contracts. This is a standard 1-year rental contract. And you just fill in the forms and people like to use these because they know it's up to date and it complies with the law, because it's very important in UK, US that contracts comply with the most recent law. Now, what does that involve? Well, I've given you seven factors that are usually to have a sound, legally enforceable rental contract. These are the ones that you have to have. Now, so we name the landlord and the tenant, we identify the property, specifies terms and conditions for rent payment, very important, usually done monthly here. And in the US, it's very common to do things monthly, gives the duration of the tenancy, it provides the terms and conditions of the tenancy, and specifies liability for damages and repairs, and that's a very important thing that any property agreement should have. And then finally sets down clauses for termination and renewal. Sophia, is there any vocabulary here that you or our listeners would like to discuss a little further?
I would say no, because everything is clear, but we do have 2 questions that pop up. The questions are as follows. The first one, do the tenants need to refer to a lawyer in order to get the agreement? So,
okay, not necessarily. Usually what happens is that you go through an estate agent, okay, or a realtor. And this would be the person that is selling the property on behalf of the landlord. The realtor, even though these people are not lawyers, they will be up on the latest in property law. And usually the realtor will give you a standard agreement, and you can be sure that this agreement satisfies the most recent legal provisions. For example, in the UK now, there are certain standards about electricity that have been tightened. So you have to have fulfill certain requirements with your electricity that they didn't have before. And so the realtor will have this agreement that is up to date, and it will give the realtor or the real estate agent or the estate agent will give it to both parties to sign. Now, sometimes people sell without a realtor. They sell privately and, or sorry, rent privately. And you do see these, there are forms that you can buy from the internet, which some people use. I'm not sure I would trust those. If I were selling in that case, I would prefer me personally, would prefer to go to a lawyer. But most people go through an estate agent who will have a standard form contract, which they will both sign.
And there's actually, thank you very much for speaking about real estate agent, because the second question that we have is actually about a real estate agent. And it was about if there is a real estate agent, who pays the commission?
Landlord.
Landlord. Okay. So that is interesting because in Russia, it's usually vice versa.
Yeah.
And that's why people.
It could be that there's a state in the US where the tenant pays the commission. It could be. There's no, but in my experience, the landlord pays the commission because the realtor is acting on behalf of the landlord.
Okay, because in Russia it may be very different because you sometimes very often it happens that that's why it's so difficult for people to move places, because you need to get a deposit. You need a payment for the first month, and sometimes, very often, you need to get a commission you pay the commission to the real estate agent. So it means sometimes 3 times the rent amount, and that's why a lot of people are trying to find an apartment, avoiding real estate agents. So it depends on the situation.
That. I've been in other countries where they have that same regime. You're paying 3 times, and that's very difficult sometimes to meet that. That said, Canada, another common law country where I lived, they don't have deposits. The tenant doesn't deposit. They consider it a burden on the tenant to have deposits. So I asked them, what happens? Well, we trust our tenants to be good. And so if the tenant leaves your flat a mess, you have to go after that tenant. So I'm happy that I'm not a landlord in Canada. The law may have changed, but when I lived there, they weren't allowed to take deposits, which was a real shock to me, because a deposit is a very standard thing in the UK as it is in the US.
And can I ask a question? How much would be in percentage a deposit, like equal?
Usually it's 1 month's rent. Usually it's 1 month's rent. So usually you're paying 2 months' rent on your first payment.
Which makes sense. Yeah.
Yes. Okay, can we move on from that?
Yes, no more questions.
Okay, it's our first. Okay, and since I know we have some really great thinkers in this group who come regularly, I've not made these questions easy. I've made them complicated because I know that we have people who love these complications and to discuss all the little problems there. So I'm throwing you a curveball, and I'm wondering, which of these provisions would you not find in a rental agreement? Okay.
And while we're waiting for the answers, can I have a question? Can you please explain several of the expressions, because I suspect they might be
very happy to.
Yeah, the fixture and wear and tear.
So a fixture is something that is put into a property. So you have the shell of the building, and for example, I know it's different in some countries, and when I was in Germany, I was really shocked because a kitchen in Germany is just a room, and you are supposed to put in your refrigerator and everything. I was really shocked when I was first there. Fixtures are things like stoves, refrigerators, things that have been fixed to the property. So anything that is attached to the property, for example, like a ceiling light, that would be a fixture.
Mhm.
Wear and tear is, now, if you live in a property for a year and it's freshly painted, you know, when you move in, oh, beautiful. If there is a scuff on the wall, a tiny little, we would say a scuff, a mark, that would be wear and tear. And I won't tell you what the general rule is because that's going to give away the answer, but we'll talk about wear and tear once we have the answer.
Mhm.
Okay, so I've seen some answers here. So Riza has said it's the fourth one, a provision allowing the landlord to check the property at any time. She's saying that no, that is not what we would have. Do you have any other people suggesting?
Yes, I also have several people who would support Raisa. And
Okay.
I also have Darius who thinks that it should be number 3 about wear and tear.
Okay.
And we also have some comments, some additional comments on our discussion. Marusia also says 4. So, and Sergey says in Russia, it depends. It's speaking about the commission. It depends on the situation. Sometimes tenants, sometimes the landlord might be. And Farah says that we don't have regulation of realtor area. That is not a very nice thing. So
Wow.
Mostly everyone agrees that it's number 4, but we also have some people who think that it's number 3 as well, wear and tear.
Okay. So the provision giving the tenant no liability for wear and tear. Now, if I put liability for wear and tear, that, yes, that would not be in the agreement. But I'm being tricky today because I know you're all very, very good lawyers. So generally, a tenant is not liable for wear and tear. So it would be, the provision would be something like the tenant is liable for all damage to the property save wear and tear. Because we realize if we live in a property for a year and there's some scuffs, some marks on the wall, there's some marks on the floor, that's okay because that is what happens in the normal course of living. And we cannot force our tenants to be liable for such things. So yes, the correct answer is the fourth one, a provision allowing the landlord to check the property of any time. Now, the bonus question, Sophia, the bonus points are there is a concept that this idea of the landlord entering into the property is related to, and somebody gave that as vocabulary today. So I'm wondering if someone remembers this idea of the landlord coming into the property, what protects the landlord from coming into the property whenever they want, he or she wants.
Mm-hmm. And Marusia says quiet enjoyment.
Oh, bingo. Yes, the concept of quiet enjoyment. And that is going to lead us on to discussing implied terms in leases for landlords. So let's park quiet enjoyment for a moment. We'll get on to that. And we'll talk a lot more about that. I want to look at this word, though, implied. Implied, because that's a very interesting term that carries a lot of weight. So, Sophia, would our viewers, would this be a new term for them, or would it be something that they would be familiar with, would you guess?
Some yes, some no.
Okay. So we have 2 types of terms in property agreement. We have explicit terms, ones that are written down, and then we have implied terms. And these are terms that are written or even in the case law, or they're actually written into the law itself. that we say every lease, these are a part of every lease, even though the lease says nothing about this term, we don't care. This term is an automatic part of every rental agreement.
So it means that it's not stated in the lease, but nevertheless we take it into account.
Yes, and exactly. So it does not have to be stated. The property law of the UK, the US says, in this case, we're actually focusing on two implied terms from the US, says, we don't care. Even if you've not written it into the lease, we are legislatively mandating that this must be in the lease. Full stop. Okay, and this is a very, very interesting area because, and in the States, there's controversy about this particular area because these implied terms are favoring the tenant. These implied terms favor the tenant. Okay, is your mind blown?
That's very interesting. I'm just thinking what it could be. Yes.
Okay. So let's get on to quiet enjoyment. Now, I'm really thrilled that some people have discussed this particular concept because we had it last year at this time when I did another session on property. I did introduce this concept of quiet enjoyment. So I would hope it was me that introduced it to you all, but maybe not. Maybe you.
I'm sure it was you. So.
And I remember, Sophia,
it's an implied thought.
Yes, it was your favorite word from that property seminar that we did. It was.
And Marusia actually says that, yes, that's where I learned about it. So yeah.
Excellent. So I have done some good in the world. Okay. So quiet enjoyment, if you look at my picture here, this is the epitome of quiet enjoyment. Nobody is bothering this person in this flat. And it's a wonderful phrase because it really just tells it like it is. We want to have peace in our property. We're paying rent, so we have peace in our property. And notice it's quiet and peaceful. Okay, so there's a sound aspect and there is an entrance aspect to it. And basically the landlord cannot interrupt unless the tenant consents. So for example, if the landlord needs to make repairs, the landlord is not entitled just to come at any time. The landlord can negotiate with the tenant and say, okay, I need to make repairs for the stove. The guy or the woman or whoever's repairing the stove will come on Monday at 5. Is that okay? Yes, it is. So the landlord would need permission, for example, to enter the flat to make repairs. Let's stop there for any questions or comments about quiet enjoyment. Do we have any?
Yes, actually, we do have two, which are very closely related. First of them is, can we say that quiet enjoyment is like privacy, or it's they are different concepts? That is the first.
That's a very good question. I think privacy is an element of quiet enjoyment. But quiet enjoyment has a bigger
scope.
Privacy is one element of quiet enjoyment. Quiet enjoyment encompasses a lot more things. For example, you can have, in my flat, the people who are drilling, I have privacy from them. They're not looking inside my flat, but they're making a noise. They're making a noise on the other side. So I don't have quiet enjoyment. I don't have that piece of the property. So sound, light, there are all sorts of things even though we have our privacy, they may interfere with our quiet enjoyment because it's coming from another source.
Okay, so then actually two more. One question said there is another one just popped up. So the second question, is quiet enjoyment related only to the relationship with a landlord, or it's a bigger, as I think you answered it. So it's not only a landlord. Yes, it's just everyone around.
No, it is with the landlord. It is with the landlord. And for example, a repairman of the landlord. So this is a property concept that is related to people living in a rental flat, and it's about the relationship with the landlord. So for example, if there was some random person, okay, I'll give you a really good example here. Right now, there is scaffolding on the building across the street. Okay. Now, if somebody is in their flat and a workman employed by the landlord comes and looks at the person in the flat, the person may say, "You're interfering with my quiet enjoyment." But if some random person walking on the street comes and looks in that person's flat, that is a different thing because there is not a contract between these two people. So because you have a rental contract, the landlord has a special obligation not to interfere in your rights. Now, if I wanted to sue this person who's looking inside my flat, this random person on the street, it would be a tort. It would be invasion of privacy. So we would be suing in a different branch of law. But this is obviously we would have a stronger case because we actually have contractual relations between the tenant and the landlord. So your suit there would have a lot stronger basis because it's hard. Tort is hard to sue because you have to prove the elements. But here you just have to say, look, I have a picture of this workman looking inside my flat. It's interfering with my quiet enjoyment, which I have by right.
There's also a question, thank you very much, from Farah. The question is that a part of right of use, quiet enjoyment?
I think you could argue that. Yes. Yes. The idea is you have fulfilled your duty in paying the amount to the landlord. So he gives you access to the property and the right to use the property. And you should be able to use that without interference of the landlord.
And the last question that also popped up is the concept of quiet enjoyment American, British, or both?
Both.
Okay.
It's ubiquitous. It's ubiquitous in common law. It is a common law property concept that is. I couldn't imagine a common law. I haven't encountered a common law jurisdiction that doesn't have this concept. It's one of the fundamental principles. Here, we are just talking, we're looking at the American concept of it, but it's very similar in the UK, this idea but the situations, because there's a different housing stock, the housing stock here is much older, so there's all sorts of even bizarre permutations of quiet enjoyment that you may have in the UK that you would not have in the US. But the basic idea is if you are living in a dwelling somewhere in the US or the UK, you have that right and you are renting. You are renting. If you're living and renting somewhere in the US and the UK, you have this right.
And there's a last question that also came up from Sergey. As I understand, it's phrased like quiet enjoyment within renting premises, as I understand, opposing to like ownership, or probably. So is quiet enjoyment within the renting premises, maybe only? So
yes.
There's like
yes.
Oh. Okay,
yes.
That's very interesting
because
I always thought that it's like in general to every property. When you speak about nuisance, for example, it's interference in.
Okay. See, this is the thing. Nuisance, tort tort, or criminal law.
Yes.
Okay, so remember that when you sue someone, you have to sue in the right branch. And I don't know if this may not be a civil law concept, but we would consider something like nuisance different. Okay, so if somebody, for example, in the next flat is disturbing my flat, okay, I can't say quiet enjoyment because I do not have a contractual relationship with that person. I don't have that person and I have no, we happen to live beside each other. So I would have to go to a different branch of law to get a remedy.
Okay, thank you very much, because I always thought that quiet enjoyment is a necessary part of nuisance, but no, a discovery. Okay, now understandable. Thank you.
Yeah.
So no more questions about the quiet enjoyment.
Okay,
yet.
so we're going to have a scenario. Okay, so here is a quiet enjoyment scenario. So in this particular case, there was the landlord is East 76th Street Corporation. And I think this is probably your classic New York City. There's a landlord that owns a building and the tenants are renting out apartments from this landlord. Okay, so very similar to what you would have in Russia in your condominiums or your apartments. So this company was constructing a disabled ramp and walls, and it covered a large portion of a private garden entrance of the plaintiff Cortez to his apartment. Now, it got very bad, this construction, and he left the apartment for 2 weeks because there was dust, debris, noise, and vermin caused by the construction. Now, I already know that everybody's favorite word of the session is going to be vermin, but I probably think it needs a
explanation.
Explanation. Okay. So vermin is a very common property term, and it basically means wild animals like rats, mice, but also includes things like insects and fleas. Okay. So, vermin are ubiquitous, but it's very much used in property cases. We talk about vermin. Ugh. And it's a word that sounds terrible. You'll remember it because it sounds awful. Vermin. Ugh. Yes, creepy. As we would say, sort of the informal phrase would be creepy crawlies. Creepy crawlies. So this is our situation. Now, our key fact here is that the lease states that this company was not liable for interference with light, air, view, or other interest of Cortez, except by its own negligence. Okay, so
that complicates our case scenario.
Yes, it does. It does. I'm not giving. You all love the difficult things, so I've decided that we're going to go with our audience here because I know that people enjoy these really naughty cases. So notice here that the company could interfere with the light, air, and view if it was not negligent. Cortez is saying it was negligent. I have mice running around and all sorts of other disgusting things, and I have to move out of my apartment because of this construction. Now, let's pause there. Do we have any questions about this scenario, or is there anything that needs further explaining?
Not yet. No.
Okay. So here's our magic question here. Now, should Cortez's claim of breach of quiet enjoyment be dismissed? Okay, this was the question that the court had to decide. Now, dismissal.
Yeah, that's a question. Yes.
Yes,
What would it
exactly.
mean?
And that's why I'm going to explain. If we apply, okay, if the defendant says this case should be dismissed, the defendant's saying that it's a ridiculous case, it's stupid, and we should not even go to court in this case because there is no case. And that is exactly what the defendant did here. Now, you as the judge, would you dismiss this outright, or would you say, we have a question of quiet enjoyment here. So this is what I want you to contemplate. So which do you think, which of the three options here do you think is the correct one here? So we should dismiss the claim because the landlord has a right to construct a ramp, or no, we should not dismiss the claim because the landlord could not do any building work, or we should not dismiss the claim because it meant that Cortez could not peacefully live in the property. So which one do you think is right? And I realize this is difficult, but I see this is what our audience wants. So that's what I'm going with.
And I will just, while we're waiting for the answers, I would just want to clarify. So dismiss, it means that the claim would not go any further. So it will not be accepted and then wouldn't go on trial. Yes?
Exactly. That is what the defendant, that is what this East 76th Street car was saying. This is ridiculous. Why are we wasting our time in court? We should dismiss this case. But Cortez says no.
And that's very interesting. Yeah, I can see it's 2019, so it is a very recent case.
Yes.
Okay.
So I'm seeing everybody online is a bit shy on mine. Do you have any answers from yours?
Yes, and I have very active. I have got a total, I have unanimous answer. Everyone is I like this, anonymously or unanimously voting. They're saying 11111. It's Vladimir, Sergey, Daria, Marusia. Everyone say one. No, the landlord's actions meant Cortez could not peacefully live in the property.
Okay, and you are correct. Yes, this is a classic case of quiet enjoyment, and it will go down to the trial court, and then we will have a full trial about whether this amounted to quiet enjoyment. Now, notice here I have some links for you. So those of you that have the presentation, you can click on for some more information about quiet enjoyment, and you can also click onto the actual case itself. Now, notice it says NYSAD. So what does all that mean? Where is this case happening?
So, New York.
It's a New York State case. A New York State case. Exactly. Okay.
And what is interesting, we still have some answers. We have Ekaterina who says 1, and we have one person who did not agree with the court. So that is interesting. That was the one. So,
and you know what? The court could have gone the other way. You know, this is why, like property, when it goes to the courts, the judges will look at the facts of the case, and the court could have argued in another way. The court says, of course, this needs to be dismissed because, they were constructing a disabled ramp. They have to construct this ramp in law, and the tenant was being ridiculous. So there was another scenario when the judge could have decided the other way. In this case, the judge said that there was a quiet enjoyment issue, and so this needs to be discussed. It cannot be.
Probably the judge also had experience with vermin and
maybe
or tenant.
Maybe. Okay, let's move on. So the second implied term we're going to talk about is the implied warranty of habitability. There is a $5 word, habitability. And this is, again, a very general concept. and it will be decided on a case-by-case basis. So habitability means that the landlords have to keep their property habitable, livable. That means someone can live in the property. And in the US, okay, again, we're getting very specific and looking at American law here. Habitability means complies with the local housing code. So there will be housing codes that say what the property must have to be acceptable in an acceptable state for living. And you can see these properties, I've given you pictures of, they do not. And you can also see that if you look at a code, again, it will be open into interpretation as to what type of property is habitable and what type of property is not. So we're moving on. We have a habitability scenario. Okay, so this is a case in which Jarvins and other tenants of the lessor or the landlord First National Realty refused to pay their rent. They said the premises were uninhabitable. And in fact, they alleged 1,500, that's a lot, 1,500 violations of the local housing regulations. That is a lot. Okay. Now, going to our key facts is that this apartment was located in the District of Columbia, Washington, D.C., and in their section 2501 of the housing regulations, they said you cannot rent something unless the apartment and its furnishings are clean, safe, sanitary, in repair, and free from rodents or vermin. There's that wonderful word coming up again. So this code is very clear on what habitability is. But again, we would have to look at each individual apartment and each individual case to say, okay, does this meet the threshold or does it not? Sophia, are there any terms or concepts here which we should explain a bit further?
Probably some, I'm not saying that we are sure our legal eagles are flying high, but some people might have issues with the word alleged and wrong.
Okay. So alleged to allege is a fancy word to claim. And this is used in court for, this is what we claim. It may or may not be the truth. It may or may not be the truth. And that's really important for this scenario. It may or may not be the truth. So they're saying, look, these premises are disgusting. Okay, we can't live in them. There's mold, there's broken windows, and we're not paying our rent. Too bad, landlord. Any other concepts? Sorry.
Yeah. So there were, I have a question then. Sorry.
Yeah.
So it's not a question from our viewers, just from me, but it means that in the first place, they still signed a rent agreement. So they agreed to this in an uninhabitable place, and then it means that they decided to complain. But it means that originally they agreed to them. They didn't make them uninhabitable. So they agreed to these premises from the very beginning. I may be spoiled.
No, not necessarily you spoiled anything. Even if they agreed to them, notice what the housing regulations say. Okay, so now we're getting down into specific housing regulations. Even if the tenants agreed, they still violate the housing regulations. And habitability means complies with the housing regulations.
Okay, and we have some comment actually on YouTube. Farah says that in our reality, if a tenant signs a contract, you don't have the right to terminate because the flat was uninhabitable. That's what I was saying. Yeah, so that's like
Okay.
so it's a different approach.
So
That is very
let's get on to the actual question of this case.
Mhm.
Okay, so are these tenants entitled to withhold the rent if the property meets inhabitability requirements? Okay, so there are 4 options here. Is there any vocabulary, Sophia, that we want to
withhold.
go over?
Yeah. For someone, maybe withhold may be a difficult one. So although
Okay.
it's used very often in contracts, but some might not be aware of it.
Okay. So withhold means refuse to do something. So in this case, they are keeping the rent and saying, look, this property is inhabitable. We are entitled to not pay our rent. And this, in this case, for the month of April. And in this particular case, the landlord was suing them for a rent. And so they had said, no, you have violated this implied warranty, so we're not going to pay the rent. Or you violated housing regulations. Like you violated housing regulations. Let me correct myself.
Okay. And while we're waiting for the answers, and there are a lot of them,
Good.
so well, for the options, so we have a question from Alexei. So the question is as follows. So you cannot change implied terms even if you want.
Yeah, because this relates to unconscionability, which we discussed. I know we mentioned this concept in the first session on contracts. Our legislatures have decided that to bargain your way out of this agreement would be unconscionable. It's not good in the public interest. If somebody says, I don't care, the property is terrible, I'm going to live here anyways, I don't know, I'm desperate, the rent is cheap, da da da. We are saying it's not good public policy to allow people to refute those rights or to give back those rights. So yes, you cannot repudiate those rights. That's the word I was looking for. Repudiate those rights.
Like unilaterally terminate yourself.
Exactly.
Okay. Thank you very much, which is very, so we immediately would like to ask a question like, how about the freedom of choice maybe? So but there is this limitation. Okay, we actually have the answers.
Okay.
Everyone unites. Sergey, Ekaterina, Vladimir, Yana. So Nikita, they all say 3. So yes, Farah, everyone says 3.
Okay, and yes, everybody has said 3 from me too. And you are correct. Okay, so yes. Okay. Being inhabitable is a material, or being habitable is a material term. And again, we're going back to contract law. It is a material term. And if a landlord supplies premises that are inhabitable, they have materially breached the contract. There is no way that that's a minor breach. If you cannot live in your flat properly and, it be safe and repair, then there is a major breach. So, yes, okay. In this case, it was a very complicated case. And at one point, the landlord, for other reasons, went to jail. It was a very, very, very long, drawn-out case. It's very interesting if you actually read this. So I would highly recommend to read all of the twists and turns that this case took. But this case in 1970 established the idea of the implied warranty of habitability. This was the first time in which it was enshrined into law. Because there were, I mean, obviously, if you go back in American history, like to the, to the 1890s and 19, we had the slum housing and it was awful and terrible. And you see pictures of people living in squalor, that all informed the developments to the idea that there is this implied warranty of habitability. And we have the case here. So those of you who have the presentation, you can have a look at the case, and you can also have a look at more information about the implied warranty of habitability. I would say that this is a little bit controversial, this implied warranty in the US, because people could get, there's one little window broken. Oh, my flat's inhabitable. So if the plaintiff, if the lessee is a bit overexcited about this defense and doesn't pay rent, this also causes a problem. So this is all it's a controversial area of law in the US.
And Divan also says that, comments that in Russia, if the property cannot be used and it's not tenant's fault, then the rent is not paid. So that's why we had, I think, everyone also who supported it. So
okay.
not only this
That's
reason.
very interesting. That's very interesting. Okay, let's see where we are. So I think, is it time? Yeah. Okay, so are there any remaining questions that we can answer about this habitability or any other property?
We don't have a question on the habitability, but we do have a question about squatters.
Right.
So there is a question about, are there any squatters' rights in the United States that you are aware of?
No. I don't know. You would have to, again, you would have to go to the property regulations, city codes of the particular city that you are looking at. There may be, I think, like in the UK, I've not dealt in squatters' rights in the UK, but I think if you establish a period of time in which you squat, you may have some rights, but I'm not an expert in that. This is a very good research project.
Okay, and everyone, so if there are any questions, please, you are very, very welcome to
So
ask.
while we're taking the questions, let's look at our memorable words. So I'm curious as to what type of memorable words, and I know I think it's going to be 90% vermin. That is my prediction.
Okay, so we do have, while we're waiting for the answers, so on the most memorable word, we do have several questions. First is from Farah. In a commercial real estate lease agreement, it is important to observe the purpose for which the premises are provided. So maybe it's not a question, but just like a comment, so which is essential. So then there is a question from Jana.
Yeah, I agree with that, and this is something that we would have, and there are also zoning. A city is involved in a lot in properties, city regulations. So there are certain zones for certain activities. So for example, if it is a residential zone, you cannot lease the property out for business. So you not only have the written agreement between the landlord and the tenant, you would have city zoning procedures to follow, and that agreement should follow it. If the agreement doesn't follow the city zoning procedure, the city zoning regulations, then that agreement would be nullified.
So, and there is another question from Jana. What clauses of the main agreement could be the subject of stipulations? So, I mean, maybe not stipulation, but maybe like the controversy or like disputable, probably. So, or maybe
okay, the substantive dispute.
From your experience.
Yeah. let's see. So if we go back, okay, I'm just going to go back to this scenario here. Sometimes terms and conditions for rent payment. So for example, sometimes contracts don't say what happens if the rent is late. And then they'll have to negotiate, you know, as to what will happen. Sometimes, let's see, usually there's controversy about repairs because the landlord will be liable for repairs, but how quickly does and I'm sure you have this problem in Russia too. Sometimes you have a landlord and you're, please repair my flat. It's been a month. Please, I have no water for a month. So the actual quality and the duration of when the repair should be, the timing of the repair is often disputed. And sometimes, if, for example, the lease ends and the landlord and the tenant have an informal agreement, oh yeah, you can stay here for another few months. So when the lease ends, what happens? So does the tenant have the right to renew the lease? If the tenant is living without the lease, if there is no lease, what rights does the tenant have? Because sometimes you have an informal agreement. So I think those are the areas which, you know, you would have the most controversy and the most litigation, where things are not quite specified. In some jurisdictions, tenants have the right, if they want to renew their lease, they have an automatic right to do so. In other jurisdictions, they don't.
Okay, there's another question. Thank you very much. So from Ivan, if somebody rents a whole building, what happens to the land plot the building stands on it? Is it a part of the rent agreement or not?
What happens to
the plot of land on which the building is standing? So if somebody rents a whole building, what happens to the plot of land on which the building stands? Okay. Is this a part of a rent agreement or not, like from your experience?
The lot would be owned by the landlord still, and the tenant would be renting the right to occupy that lot, but it would no way affect the ownership of the lot itself.
Okay, thank you very much. Another question we have actually related to eviction. I think someone had an experience of eviction or maybe watched this in United States. So how quickly, first question, there are two of them. How quickly can eviction happen in United States? Like, what is the time period?
Yeah. Again, it's going to depend on what the law says you have to do to evict someone. So there will be a procedure, a legal procedure for eviction. I know in the UK there's a certain number of steps that you have to take, and it's designed to protect the tenant, and sometimes it can take a long time. But you would have to look at the local law and they'll give you a series of procedures. It's not something that's quick in my experience. It's something that you have to, we would say, jump through a number of hoops in order to evict someone.
Okay. And actually, there are two more questions related to eviction. I think that someone had some not an issue with it, but maybe an interesting topic. The two questions are as follows. So how, not how much. So like I would need to rephrase it a little bit. What can the landlord deduct or demand the money or claim the money that he or she spent on the eviction from the tenant somehow? And the second question, is the fact of eviction registered somewhere, so it may spoil the future history of rent history of the tenant? So
Okay,
that's-
these are really good questions. So if you're in the UK, the landlord can claim money from the deposit as legal expenses.
Mhm.
And I was involved in a case like that. So the landlord said, look, I spent £200 on a solicitor to effect this eviction. I don't know what the law is in the States, so I don't want to venture. There could be something very similar like that in terms of taking money from the deposit, because this was an expense that was not predicted, that was obligated for the landlord to retain the property. So I would say yes. The second question, it was a good one. Well, can you remind me of that, Sophia?
Yes, the question was that is the fact of eviction registered somewhere
Oh,
on
okay.
the tenant history of the tenant?
Yeah, not necessarily, but if you are renting through a realtor or state agency, they usually demand that you have references. So they will demand references, they'll demand bank statements, proving that you can pay. There are a number of checks, and this is why people would rather go through a realtor. The landlord would rather pay money, a commission to the realtor, because the realtor is going to go and do all of these checks to make sure that somebody will be a reliable tenant.
Mhm. And then I have a question from me, actually. So I've read recently a story that some pair of Hollywood actors or something like this had some dispute, and they were using an argument for some dispute. It was some childcare dispute, that they together submitted a letter, application letter, either for buying or for renting a house in UK. So they actually wrote an essay to the landlord or to the seller, proving them that they would be the best candidate. It's very weird for Russia that you would send an essay. So there would be like a competition for among the several candidates, because in Russia, if they have several people, well, if your property is very, very popular, or maybe some other countries, you just raise up the price. And that it kind of eliminate the candidates. I'm sorry for being so direct. So is there really a habit of or like a tradition of writing essays or letters to the person who is
I think that's weird too, Sophia. So I've not heard of that. But you know, actors live maybe on another planet than we do, and they that's what they tried to do. So yeah,
Okay.
this is something new for me.
This is something new. Yes, I was like so surprised that they were using it as an argument that they were together planning to do some plans. And we actually do have two more questions that popped up. Well, one more. So Alexei asks, what is the longest term of the rent? Can you rent property for like 99 years, for example?
Yeah. Okay, so usually it's 1 year renewable. But remember, and this I know blew Sophia's mind. Remember that in the UK you can buy a lease. Remember, in the UK you can buy a lease, and so it can be. You can buy a lease for 999 years. You can buy a lease for 200 years. So in the US, this is not a concept at all. You don't buy a lease. Here you can. So in those scenarios, in the common variety, renting a property, it's usually 1 year at a time, renewable. That is the standard in all common law jurisdictions. It would be very rare when you would have what you would say a long lease. I leased this for 7 years. It's not what's done.
Okay, thank you very much. Yes.
Okay, so let's get some vocabulary. So what are the terms? What are the memorable words?
You know, the winner is habitability.
No, no. Well, that's good. That's good because that's obviously the legal word. Oh, I mispredicted. Okay.
Not a single vermin.
Not a
So,
single vermin. But you know what? I guarantee if you forget everything from this session, you're going to remember the word vermin.
yes, and the rodent.
So
Yes,
let me just follow up on one more thing. I don't remember who it was from the last session, but someone wanted some more information about anticipatory breach.
I even remember who it was. It was Magomed, and he's one of my students. We even discussed it during the class.
Wow.
It was a very, very complicated concept for us. So we still didn't, I think, get it until the
That's
end.
absolutely fine. So in my presentation, there is a link to a NOLO article, okay, on anticipatory breach. And NOLO is one of the legal information services that takes a complicated concept and explains it for, we would say, laymen. So people that are not necessarily lawyers, but want to have this understood, have a concept of law understood, and they want to go into it. This article is great because it gives examples of what anticipatory breach would include. So I recommend that you and your student have a look at this article. I think this will give you a lot of very real life examples that will, or real life scenarios that will make this concept clearer.
Thank you so much. Thank you for
So that is all we have for today. Again, many thanks for your participation. As you can see, I love property law, and it's a very interesting field. And I'm so delighted with all of the very intricate questions and the observations. And so our next session in 2 weeks' time will be about sales. So selling a piece of property, a house, a flat, to someone else. And that's again a whole exciting area of law that we have yet to study. So thank you so much, Sophia, for all your help, and thanks to everyone who has been very active on YouTube, Telegram, and my presentation here. It's always nice to have your individual comments and your questions, and to also learn from you about what your situation is in the fascinating world of property.
Thank you so much. Thank you. And we have also a lot of thanks from our viewers and participants. We do thank you so much because the fact that you are here makes these webinar sessions live. And I think I can speak on behalf of all of us. We're super excited that we have the audience, that the audience needs this, that all the information that we study. And thank you, everyone. And Daniel, we have congratulations to you with the 8th of March, because it is approaching. It's going to be a public holiday in Russia. It's a big thing. So, and our viewers are congratulating you as well, because it's not only the Women's Day in Russia, but also the Spring Day in Russia.
Thank you. I know when I had Women's Day in other countries, they gave me flowers. So I'm now accepting your virtual flowers.
They are, yes, virtual flowers, because it's the flower day, yes, in Russia. So tulips and others. So, and we're giving it to you as well, our virtual flowers. Yes, thank you so much. And we're going to see you, everyone, in 2 weeks' time. And have a good evening, and see you in March. Yes, in March. And bye-bye. Bye-bye, everyone.
Bye-bye. See you in 2 weeks' time.
Thank you. I see you in 2 weeks' time. Thank you.